Hi, good afternoon, everyone. Can everyone hear me?
Yes.
Okay.
Yes.
Hi. It looks like we might be missing one or two committee members, but we'll go ahead and get started just in the interest of time. There's a lot to cover today. So I guess we'll do our usual. We'll go around the room and introduce ourselves. You guys know me. I'm the chair.
Michelle Cummings, facilitator.
Justin Teff, Clerk and Teff.
George Stollis, Workers' Comp.
Stephanie Zufali, Workers' Comp.
Meredith Woods, Workers' Comp.
David Wertheim.
Mindy Roller, New York City Law Department.
Okay. And we'll start with Rochester.
Brian Trick, Wegmans Food Markets.
Okay. White Plains.
Winston Quat, Mount Sinai.
Okay. And Manhattan.
You're up, Joe. Joe Countess, New York State AFL-CIO. And Robert Goldberg, Medical Society State.
Okay. Thank you guys so much for being here. Take it away, Michelle.
All right, so as we discussed in our last session, to give us time to complete the IME Advisory Committee recommendations report, we made some changes to the remainder of the 2019 schedule. Since our last session, we distributed a draft questionnaire for your review. After our presentation today on the IME process, we will review that questionnaire with you. Based on your feedback, we will make changes and send out a finalized version of the questionnaire for you to complete and return to the board by September 3rd. Our plan is, at our September session, we will review and discuss your responses, as well as review an initial draft of the report. At our session in October, we plan to present a revised version of the draft report, including your responses, and review together as a group. And then November and December, the schedule remains essentially the same. We will look at the draft report again and then put it into final format at the end of December. So for today, what we would like to talk about is topics related to the IME process. First, we will discuss records reviews versus in-person exams, including their evidentiary value, when they are used, when they should be used, and the relevant workers' compensation regulations. We will then discuss the regulation and monitoring of IME providers and entities. We will revisit the same day, same manner rules, determine if there is consensus, and discuss possible recommendations. We will also discuss for IME provider assignment, including state physicians, panels, or statewide networks, and other arrangements. We will discuss the appropriate use of claimant questionnaires and review proposed regulatory changes. At that point, we will take a 15-minute break, followed by a review of the advisory committee recommendations questionnaire. And after that, we will summarize and then go into executive session. So at this point, I would like to turn it over to George to get us started in talking about the process summary.
Thanks, Michelle. Good afternoon, everyone. According to the IME utilization study, we found that the vast majority of IMEs, 94%, are in-person examinations. The remaining 6% are record reviews. Providers apply for authorization to treat injured workers and/or perform IMEs either through their appropriate county medical society or directly to the board's medical director's office, depending on the provider type. If an authorized IME provider is not available, which we found to be less than 1% of the time, or when an injured worker is out of state and requires an IME, the IME may be performed by a non-authorized medical provider, for example, an out-of-state provider. IME entities are required to register with the board using the board's IME 7 form. Approved entities must re-register every 3 years. While it's difficult to quantify the extent to which it happens, analysis conducted by the board revealed that an IME provider can sometimes be booked for the same time slot on the same day by different IME entities. There are three sources of guidance related to the current rules and regulations on IMEs. Regulation 300.2 and subject number 046-666 discuss and include direction about notices, provision of information and requests for information, reports of examinations without physical examination or records reviews, videotaping of IMEs, IME reports, exemptions, IME entities, suspension and revocation of the authorization of IME examiners and entities, and the right of the board to request information or documentation necessary from any IME entity for the purpose of administering and ensuring compliance. Subject number 046-324 discusses proper communication between IME providers and carriers or self-insured employers. To conduct independent medical examinations, currently providers must apply to the appropriate county medical society or directly to the board's medical director's office, depending on their provider type, using the board's prescribed IME-1 form. In the future, this process will be improved through an online electronic application process, which is under development. Today, to become an authorized IME entity, an entity must submit an IME-7 to the board's medical director's office for review. Approved entities, as I mentioned earlier, are required to re-register every 3 years. Currently, there are 73 registered IME entities, 17 of which are registered, but have advised the board that they do not perform IMEs for workers' compensation claims. Listed here and also included as handouts for your reference are a list of the board prescribed forms regularly used as part of the IME process. The IME-3 form is used to convey examination request to IME provider to document or to document other relevant information. The IME-4 is used to document the IME provider's findings as a result of the examination. The IME 4.3a is used to detail the degree of permanent disability and a schedule loss of use claim. The IME 4.3b is used to detail the level of disability in a permanent non-schedule loss of use claim. And finally, the IME 5 is used to notify the claimant of the date, time, and location of their examination. As a reference, we've provided the process flows for both IME in-person exams and also record reviews as handouts. This table compares in-person exams and record reviews. In both cases, the carrier or injured worker can request an exam or review. The IME entity selects the IME provider and schedules or orders the exam or review. In the case of an in-person exam, the entity notifies all parties of interest within 7 business days using the IME-5. In both cases, the IME provider performs the exam or review. If the injured worker requires translation services or transportation for an in-person exam, the IME entity will make arrangements. This does not apply to records reviews. The IME entity uses the IME-3 form to provide information to the IME provider in both cases. Also, in both cases, the IME provider submits the IME-4 to all parties of interest on the same day in the same manner. If there are no questions, I will turn it back to Michelle.
I just have a quick sort of question.
Yeah.
On this particular page, where it says requester is carrier or injured worker, and then it says provider selection IME entity. I don't think that in the case of an injured worker that they go to an IME entity.
We have seen that on rare occasion, but I would agree with you generally, it's not done through an IME entity.
This is Robert Goldberg. You talk on slide number 6 about healthcare providers going to county medical societies. Please use the term physicians when referring to physicians. If you're talking about other people, there are other preferred terms. Certainly a PA or an NP will not go to a county medical society for this process. So please go through it and use physician where you intend the word to be physician.
And also, isn't the process changing, or hasn't it changed, where they're no longer going to the county medical societies?
I still go to the county medical society for physicians.
Oh, it's only for everybody else? I
Correct.
thought it was the board that was at, oh, well, you know
They
better
go,
than me.
they get filed simultaneously with the board and the medical society for physicians.
Okay.
All of the providers come to the board.
Did everybody hear the question?
And my last question is, it says 17, out of 73 registered IME entities, 17 do not do workers' comp IMEs. And since that sort of gets to the heart of our issue here, or one of them, was there any follow-up as to why they don't?
Is it no fault that they?
Yeah,
do
they could be
They
exclusive
do
of,
no
or-
fault, they might do general.
No, it wasn't what do they do. The question was, why don't they do this if they're doing,
If they're registered.
Oh,
Right.
Some of them have advised us that they're contemplating doing workers' comp in the future, but they just really haven't gotten their foot in the door yet. If that would be helpful, if you want us to follow up with them.
well, I mean, we're concerned about having enough good providers, IME physicians in the system. I'm just curious, I don't know that these guys are good, but I'm just wondering why they choose not to do it.
Why they go through the process of registering and not bother to do it.
They may be registered for other
Right.
things as well.
These are the entities.
And they,
Yeah.
and they would have to register with the compensation board even just to do no fault exams, or no? Okay.
No.
No?
No.
All right.
Anyway,
No
it's
idea.
I was just wondering if there had been any follow-up.
There's been a lot of follow-up with IME entities on a whole series of questions that we've asked them, but not specifically to the ones who said they don't do workers' comp currently, to ask why not.
Right. So that was
Yeah.
my question.
Okay, before, does anybody else have questions on any of the material that's been presented? Okay, so for today's discussion, let's start with records review versus in-person exams. And for that, I'm going to turn over the conversation to David.
Okay. So this is one where it's a combination of a couple of different things that we've talked about already that kind of could feed into a discussion on records reviews versus in-person exams. Some of which, I want to know if the way that I think records reviews are used is accurate, or if there are other uses out there that you're aware of. So I'll start with that, which is, it appears that, the most obvious use of a records review is causal relationship in a death case. It's not otherwise typically used for causal relationship IMEs, not typically used for permanency or for degree of disability. Not typically used on the medical IMEs, which would be the C4 auths, the variances. It is used for the RFA2 OP, which is the initiation of the opioid weaning or addiction recovery process. It can be used, it's not necessarily used frequently, but it can be used for an apportionment opinion as well. But, before I go further, I just kind of, again, want to know, as a matter of the reality check, the as-is world, are we typically only seeing records reviews for the most part in causal-related death and the initiation of the opioids process?
We do see them in some treatment issues, but usually for durable medical equipment or things of that nature. That's the only thing I would add to what you've said. Otherwise, I think that's accurate.
I think that that's correct. The only thing is, we will occasionally use them for causal relationship, or it's a complicated issues somebody has developed, it's a case of epilepsy or something, where you want to look at prior records. There's no question as to whether or not the person has the condition. Question is, what was their prior history, et cetera, et cetera. And there we would want a record review. I don't know why I thought of that particular example, but I'm trying to think of.
Very complex cases.
Yeah.
Like occupational.
Right, something where it's not a question of fact as to what happened. We know the person has that condition, but the question is it causally related?
So, I think generally speaking, the view of a records review versus an in-person exam is that, again, all else being equal, it has less evidentiary weight than if an in-person exam had been conducted, particularly where, physical performance is an aspect, or psychological as well. And so the areas that you typically see it in are where that cold record, suffices. And if you used it in some of those different areas, it might be perceived as evidentiarily having less value. Is that generally
Yes.
the perception?
Yeah.
Okay. So, mixing this with one other area, wanted to throw this out for discussion, which is, when we talk about the different types of IMEs that are performed, and we look at that C4 auth with that extremely tight 30-day from receipt of the C4 auth, that extremely tight time frame on what can be pretty complicated, serious, and consequential, meaning meaningful requests for medical treatment, often surgery, that there are issues in timely procuring the IME within 30 days, because in that circumstance, a contrary medical is required. And so one of the other things that had been discussed when we last touched on C4 auths and medical billing was, the consequences for not producing a timely report does not necessarily mean that there won't be legal objections to the bill down the road, and that creates obviously problems for physicians and other medical providers. So throwing this out for discussion, does the committee want to potentially consider the idea of perhaps elevating the use, either regulatorily through exploring the evidentiary value or some other form of guidance, the use of the records review in the context of a C4 auth, such that you'll have more timely responses, and maybe balancing that out on the other side with, well, if the evidentiary barriers to the IME in that circumstance are lowered or made easier to comply with, then the other side, if it isn't timely produced, that the carrier would in effect waive all of their rights to object to the bill down the road, meaning the bill for the treatment that comes out of the C4 auth. So in other words, let's just say a lumbar fusion surgery, C4 auth comes in, the carrier or self-insured finds it difficult to get a timely IME doc such that the report can be produced within the 30 days as the contrary med. So, but rather than just kind of letting it lapse, the issue needs to be explored, so a records review would be produced. But if a records review is not produced timely, then by operation of law, in effect, the treatment would be authorized and the bill would be deemed payable. From a legal perspective, be deemed payable.
At the comp fee schedule.
What?
At the workers'
Of course,
comp.
that's why I said legal objections. So, yeah, if the fee schedule calls for a $15,000 surgery and it's billed for $40,000, obviously that's a fee schedule issue. And I know that's mixing two completely different things, but they've both been discussed here by this committee. The last time that the issue of timing on IMEs and fees were raised, so that's why it's thrown out in case it's something the committee wants to discuss.
No. I'm concerned that this will interfere with timeliness of treatment. It could prolong it, it can move it back. With the situation that you described with the C4 authorization, we want that to be looked at so a decision could be made. However, you're talking about a record review. If the record review is to allow the treatment to begin, and to agree with the recommendation, I think that could be a positive. But then what happens if that record review comes up and disputes that request? And I'm afraid that might move the clock back. How would you address that?
Well, that's what happens now with
Yeah, that's the
IMEs.
as-is.
Yeah, that's the
Yeah.
as-is, right? That's what happens now with an IME, so it wouldn't necessarily, it would be the same process.
So typically what happens there is you, the C4 could generate an order of the chair. Sometimes the physician is reluctant to go forward even with an order of the chair. And one of the reasons being that the bill can still be objected to on a legal basis after it comes in. But of course, then the doctor is at hazard because the surgery has been performed.
What's the legal basis of the objection? I don't-
There are a variety of legal bases listed on the C8.1B. I'm not saying they prevail, but it gets adjudicated.
And I'm just having trouble. What would be the net change from the current rules? Again, forgive me, I'm just,
For what?
for the idea you propose.
With using the record.
I think he's trying to.
Well, I'm trying to see if, because there have been questions about timely payment that have been raised earlier, so it's not really, it's not a proposal as much as just trying to see if it's something that we can mix the two topics together. But what it would be is if you'd have a complete waiver of defenses on the bill if a records review wasn't produced within 30 days. If it was produced, it would be the same as if an IME is produced within 30 days now, which is it's adjudicated. So it would be the same process as is now, except you'd have an absolute waiver.
Well, also, it would mean that an insurer could get a record review, do it much more quickly, and, authorize or not the surgery or whatever procedure it is pretty quickly.
I know. I'd want to give this one some thought, though, because it's, of course, in conjunction with the good doctor, it's the not that I'm more worried about. And I find that the records reviews, given their impersonal vehicle for doing the examination, tend to result in more denials than approvals. And now I see medication more than anything, so that may be the correlation there. But I guess I would want to give that some thought.
Yeah, and records reviews are, of course, allowed in this context, it's just they're
Sure.
typically not used.
Sure.
I actually think it's a good idea. But I would just say, because from my perspective, if we think that we don't get an IME and we don't generally want any IME if we believe that we think if the claimant wants the doctor's recommending a particular surgery or something extensive like that, usually nobody wants to do that unless it's necessary. So, it's a question maybe if it's closely related, there might be an issue, but other than that, I don't think we usually contest that sort of thing that you commonly, I think this would be fine. If I really had a real question, I could get a record review on it quickly, efficiently, and object. It would be helpful to me. Frankly, it's not something we do usually, but it's a good idea.
Anyone else have any thoughts?
From my perspective, it's difficult to see this as doing anything but presenting downside risk for an injured worker.
How?
By delaying care, and then even if as a matter of law, the carrier waives their objections, we'll still have doctors who won't perform the surgery or the procedure the same way we do now with medical treatment guidelines.
Can I ask a question? Because this is a real issue. Why won't, I don't understand why they won't perform it if they're required to perform it. And I frankly don't understand why the board doesn't come in, penalize them in some manner or another if they don't. They're board authorized, they're allowed to treat injured workers. I don't understand why they don't treat injured workers when they're required to. And I don't see how this creates a delay at all. It's the same 30-day period.
I would like to ask a question of Mindy. What about carriers paying for work that has been demanded and authorized by the board? The carrier may choose not to pay it, so do you want to impose the same penalty and jail time on an individual carrier that doesn't do it?
I don't know.
So there are concerns on both sides. I'm not being facetious. A physician who undergoes an operative procedure assumes a tremendous amount of medical legal risk and responsibility to that patient, independent of payment. A carrier just may choose not to pay, and there's the recourse available to a physician are scant, if less than that. So that's a response to your question.
Is there no are you telling me that under the workers' compensation law, there's no recourse for failure to pay a bill? I don't think that's true. In fact, I know it is not.
I think you'll find that the percentage of unpaid bills by carriers for treatments that have been authorized is large, and I believe it applies to many carriers across the board, but I won't single out any individual ones.
The fact of the matter is that that doesn't change a treating doctor's responsibility to his patient. If you feel somebody needs something, I don't know what the case is. I know with New York City employees, they all have insurance in any event. One way or another you're going to get paid. Why would you not go forward with some treatment that you think your patient needs?
And that I don't think.
May I just ask for clarification? Mindy, are you suggesting that City of New York employees should use their negotiated health care plans in lieu of workers' comp for workplace injuries?
No, absolutely.
I just want to make sure.
Please play this, Mindy, play this back. That's what you said, and if Joe didn't say it, I was going to say it.
No, I don't think that that's what I said. In fact, I know it is not what I said. I said in any event that was the case, so you can be assured there would be payment at the end of the day. That is not what I'm saying. What I'm saying is they're required to treat, they have an obligation to their patients to treat, why won't they go forward? And they do have recourse within the workers' compensation system if they're not paid. So I don't understand why, and if they would just go forward when they're required to, all the delay you seem to put on the IMEs and on the process would just evaporate.
Well, let me say first, your analogy to the private health, I don't think that's
I didn't
fair.
make an analogy. I just said that in any event, people often have private health insurance in the event that there is a problem. There is, in fact,
May I
let me
finish?
just, no, let me.
You interrupted me.
Okay, well, let me just finish what I'm going to say.
Please.
Which is that the fact of the matter is there's a HIM process. Oftentimes, bills that should be workers' comp are paid by the health insurer. There's an entire process within the workers' compensation law for dealing with that. I don't think that it's that unusual when there's an error in who's paying for what.
When you mention the private health, are you factoring in not only the hierarchy of insurance obligations in New York State, but timely billing issues?
I'm not talking about it.
May I finish?
Yes.
Okay. Are you factoring in not only the hierarchy of insurance liability under New York State law, but timely billing issues, such as an insurance company, even if they are obligated, once the board has found that it's not legally binding, if the bill was not timely submitted to the private carrier, they do not have to pay it. They get the same objections as everyone else does. So the idea that you would sit here and say, well, just submit it to the private health and everything will be fine and the recourses within the Workers' Compensation Board are sufficient is not correct.
Well, in any event, I don't think
And furthermore, there's a question on the HCFA 1500 form which asks specifically, is this a condition which stems or is related to employment? As soon as that physician accurately says yes, that claim is denied. So, and no physician should knowingly bill a health insurance plan other than the workers' comp carrier for something which the physician believes is related to work.
You know,
That could be fraud.
I understand that. That's not what I'm saying. And I think this is a conversation that is going in a direction which was not intended certainly by me. The fact of the matter is, I do believe that doctors have that treating doctors in the workers' compensation system have an obligation to treat, and to constantly blame their failure to do so because they are afraid of not getting paid on the carriers, on insurers, on employers, and on the board is, I think, unreasonable. I think it's a red herring to say, I don't believe that it can't be fixed if there is a problem in terms of priority of insurance payments. That's all.
What's your proposal? To guarantee that the insurance, the
I
private
I
insurance?
think she has one. I think she-
I say that what should happen is doctors should treat when they're required to. The board will ensure that they will get paid. There's ample opportunity and ample systems for that to happen. And I would think it would behoove the board to do that to strengthen that, because that's how people will get treated appropriately.
And I think the way we got here was David, threw out a couple ideas regarding records review versus in person, and, it led to a much
And
bigger
if that's something
conversation.
that the committee wants us to do, I mean, the committee can make recommendations, because this is something that did come up previously in another, one of our meetings, about the treating physicians being hesitant to go ahead with treatment for fear of not getting paid. So I think that's what Mindy is getting at.
May I ask a question of the chair? Are there any instances where a physician has followed the board's recommendation or approval to go ahead and perform procedure or surgery that was then not paid? And what recourse and what ammunition does the board have to address the carrier to demand payment and interest in those cases?
No, there is a recourse.
Bills can be there can be legal objections to a bill, there can be valuation objections to a bill, and it gets adjudicated. At the end of the day, if it's adjudicated and it's not paid, the physician or other provider can file for an administrative award. Once they get the administrative award, if that's not paid, they can request for consent for judgment, which the board will give, and that judgment can be effectuated through a county clerk. So that's the entire process.
Right, so that is the process.
Okay, that is a very onerous process, though.
Well,
Well, we're
it can't be
talking,
that onerous,
I'm
but-
just following about,
I understand.
this is what the board does, and what if
Okay.
that doesn't work? Well, then we, as
I
opposed to,
understand.
our hands are tied. That's all I'm saying.
And I think
We always
the question that
offer,
was posed is,
Right.
what do you do?
Right.
What
I
is the
think there's
process?
also some concern on behalf of the providers about, as people have been discussing, about not getting paid. And the new medical portal, which will have the medical treatment guidelines in it, will give them the ability to kind of walk through and, look up the procedure they want to do and get that instant feedback that this is within the medical treatment guidelines, and it would be covered by the carrier, and, unless there's a legal objection or something like that. So they will have much more of they'll get a confirmation back from the system indicating that this is within the treatment guidelines. So hopefully that will, prompt them to go ahead and provide the treatment, because the goal is to make sure that they understand that what they're asking to do is in fact supported by the treatment guidelines. So I know it's not going to be 100% foolproof for some of these doctors. They're going to still want something more than the system confirming that that's within the treatment guidelines. But I think it's a step towards trying to get them comfortable that they don't always need that piece of paper to move forward.
I'm thinking that what the doctor is essentially getting at is if we distill the entire process to the lowest common denominator, what it really is if the carrier doesn't pay, the doctor can sue them. And I don't know that.
Well, no, it's worse than that. We heard that you could file the judgment, and then the last sentence was, and our hands are tied.
no,
he didn't.
I said, that's the opposite of what I said. I said I was answering the question fully. At each step in the process, if the carrier doesn't do what they're supposed to do, what's the next step of relief? And I explained it in full because I didn't want to say, once we've passed the first level, our hands are tied. So I said the opposite of.
All right, so now if a judgment is filed, and what ability is there to collect on that judgment? And first of all, it's very onerous to even get anywhere near that stage.
Not real.
Are we getting
Well, I
kind of?
think-
Well,
I think we might
that's-
be getting-
That's,
We're getting
that's,
out of this.
that's like the fail-safe at the end of the process if all else has failed step. This is not the norm.
Right.
Going to a judgment is not the norm in the process. But I just wanted to answer your question.
So I think back to the original question posed by David, I certainly don't have much faith in the fact that injured workers, this would in any way speed up care for injured workers. And then also on the issue of diversion of workers' comp expenses to private health care, in addition to being fraud, from my perspective, that's theft from workers. Workers, particularly unionized workers, go in and negotiate contracts. In exchange for healthcare insurance or for partially employer-provided healthcare insurance, they give up wages, other terms and conditions of employment. They make a decision that healthcare insurance is important to them and that having the employer pay for a portion or all of it is important to them, and they give up other things. The more expensive you make that employer-provided healthcare insurance, the more the employer is going to seek to get back in bargaining in other areas. So diverting workers' comp costs to a private healthcare insurance of a worker is theft from that worker.
And it also interferes with the ability to apply for disability benefits.
Okay,
And-
nobody is suggesting this, so we're
Yeah.
wasting a lot of time.
I don't think Mindy was suggesting that.
The comment came up, and it is,
Oh my God,
it's an
do we have
important
a
issue,
better,
and
it's not
I can't.
important here, is there nothing more important that we can talk about?
It seems to me that the only thing that's important here is what you, Mindy, decide and deem is
Well,
important.
I would like that if that were the case, but I don't think it is.
Okay, that's not a fair
Yeah.
characterization. Let's move the discussion.
I
I
forward.
think
Yeah.
David fairly threw out an idea that
Yeah,
was
and-
intended to help, not hurt.
Right.
And
But I don't-
they've got, and that's what we really want to know. It seems that
But-
more of the group is not in favor of,
Right, so, but.
But I do want to thank Mary Beth for what she's pointing out, that we're going to have an online process which will then allow in real-time access and interpretation of the guides as to what should be able to move through this system without objection. And I think it's a very important point, one that we work very hard to get to, and the board should be complimented for that. Thank you, Mary Beth.
David, did you
Thank
want to
you.
add
Yeah,
anything?
David does want to
And
make one
none of that
point.
was an attack
Sorry.
against you, sir, please. I hope
No,
nobody.
it was his idea.
Okay, but it wasn't, I don't think any of
I
us,
know.
you know.
I think
Not
one of the
taking- not
things
taking
that
away.
we haven't mentioned, and I'll let David make this point, is that there's a reason for that recommendation, and it actually is, to counter your point, Joe, it might actually expedite care and treatment for injured workers, and that's part of the reason why it was suggested.
Yeah, well, right, but it's for the committee. But the other thing I wanted to mention is, that's not the only area of discussion for the evidentiary value of records reviews versus in person. So I just think, we started with kind of a specific possible idea that mixed billing with the most acute time frame, but there's also other types of IMEs and there's other timeframes. So if anybody thinks that there should be a recommendation or even just a discussion about the use of records reviews in general, I think this is the time to have that discussion.
David, this is
yeah.
Brian. I think we should at least take a chance to review what your recommendation is and then talk about it maybe next month. I think there's a lot to consider. I think we did get off on the wrong track, and I think it might have tainted some of these views on the possibility of this being a great idea. So I think we should all review it and then come back and talk about it next month, because I think it does have a lot of merit for both injured workers and for carriers.
That's fair.
Okay.
Thank you.
That's fair.
So we're going to table, if you could put that on the parking lot, that we're going to table this and David's idea and put it into context so we can again discuss it in September. At this point, I'd like to move on to the second topic, which is the IME process, regulation and monitoring, and start with IME providers. We've talked about this issue several times over the course of the last several months. High-volume providers, should there be a maximum number of IMEs that are allowed to perform in any given day? If there were, any recommendations on how it would be crafted, what do people think on that topic?
Hey, this is Rick Weinstein from White Plains. As an orthopedic surgeon, I'll just talk about my experience. There are some doctors who do IMEs for 2 hours, some who do them for 8 hours. So I would not necessarily limit the number per day, but I would limit the number per year. And a lot of the data we've been evaluating is a number of IMEs done per year. I don't understand how someone can do over 1,000 and some doctors are doing 5,000 IMEs a year. It's not possible to be done accurately and well. So I would limit it not per day, but per year.
It seems.
Can we come up with metrics for days and years? I mean, even in 8 hours, how many do you think you can do at 8 hours?
Well, it depends what you're defining as doing an IME. Doing an IME for that day could be just doing the examination, and an exam could take 5 minutes, it could take 15 minutes. The review of records could take 5 minutes and could take 2 hours. So are we defining doing an IME as also reviewing the medical records?
That's face-to-face. Face-to-face time.
Face-to-face time? So I could see probably 6 per hour as a high number.
In my experience, it's 1, maybe 2 a day, because they're over an hour. Because
It depends on how you perform them.
But you're thinking of just the examination, but there's a history that goes along with the physical examination. And we certainly would agree as physicians that the history is a very important component of an encounter with a patient, and we can't discount that. So, but even if you use your 15 to 25 minutes, does that include record keeping? Does it include other things? So to think that somebody can do thousands a year, I share that same curiosity that you do, Doctor.
Yeah, I don't see how someone could do several thousand per year. I would limit it to 1,000 per year per doctor. But I would not limit the number per day, because again, some IME exams could be 5 minutes, some could be 45 minutes.
Is there
So
a
that's-
limit on the number of patients a treating doctor can see in a day or in a
No,
year?
no limit.
Anyone else on the idea of limiting? It sounds like we're looking, potentially.
I mean, I am going to defer in part to the people who are the most expert on this, but from the claimant's perspective, it seemed, even on its face, difficult to believe that someone could perform thousands, close to 10,000 a year, without giving away almost 99% of the process, which is to say just doing 55-minute SLU exams and telling someone else to do the rest of it. So I, too, would think that no one should be doing 10,000 per year.
So Justin, I think the numbers that we've been sharing were a summary of 3 years. So I don't think anyone is near
Okay.
10,000.
Fair enough, and
Okay.
I, forgive me.
Even
I
for 3
don't
years,
Yeah,
it was
have
like
one in front of me.
capped at 5,000, right? For those
Okay.
3 years, I think it was like capped at 5,000.
Yes.
Yeah.
What was
So
the
that's
numbers we were looking
5,000
at?
a year or 5,000 over?
No, that was
Over
over
those
the
3 years.
3-year
Let me
period.
look at
So
this.
that's about
Still a lot, but
1,700
yeah.
a year.
Still.
I have the report right here. Yeah, it
Okay.
still seems like an impossible year.
So doesn't that really go to cross-examination of the IME doctor and asking him, how many do you do a day, how many do you do? Doesn't that go to his credibility and the competence of his report?
We never get into that.
In front of a jury, it
yeah.
certainly does. In front of the board, and this is not having to do with anything with the board, it's more a specialized adjudicator than a jury system. I found that the value of asking an IME how many you do, in terms of then comparing that to the validity of his opinion, does not necessarily carry the same weight here, and certainly does not lend itself to the immediate psychological notion that this should get less weight. So I don't think even the cross-examination has the effect which I think we really want to get to, which is, if you want to do these, do them well. If it takes you 5 minutes to do an SLU exam, that's fine. If it takes you 4 hours to do a pulmonary IME, that's fine. But do them well, and don't squeeze 5,000 in a year. I don't think I could represent 5,000 people in a year.
Not well.
So recognizing that the number is high, it would,
It's not 5,000 a year, just to go back.
Right, it's
about
1,750.
1,650. Maybe you could do that, maybe. No, only kidding, just a joke.
How
I
many
can barely do
is that?
one well. That's not on tape, right?
I think it is.
But, still, how about maybe more the point is that it seems that those that do the thousands have a more defined role in terms of what they expect they should be doing as an IME versus those that are a local provider, and I realize there are differences between New York City and Kingston and Albany, but there are many good doctors in Kingston and Albany that would do this and would do less of them and would mean it, I think, versus just shuffling people through their waiting room as an industry.
So is there a consensus
ahead.
on that there should be some overall annual limit, maybe broken down by month or however we want to break it down? We haven't necessarily locked down on what that number is, but there
Right.
seems to be some agreement generally that an overall annual maximum cap makes sense?
Can I just say, actually, if you do the math, and I just did, 5,000 over the course of 3 years is, is equal to about 1,666 annually.
Are you using a 260 multiple, though, so we can ensure that these IMEs are not doing them on Sunday morning, which I believe they are not?
I didn't do it, well, let me just say, so
Okay.
it's 5,000 divided by...
260 working days.
No, just hear me out for a moment, okay? Divided by 3 is 1,666, and if you divided that by 52, so we know how many, that's 32 in a week.
Assuming they're working Saturday and Sunday.
No, because then I divided that by 5.
But you didn't say that a moment ago.
Well, because that was my last part of what I did.
6 a day for 260.
That would be 6 a day, every day. So nobody's doing them every day. The point is, even that number, as high as it seemed, is not actually as outrageous as it sounds. That's
So
the
just
number.
also in the data, we typically see this is a day that an individual, a physician does an IME, and they'll have, potentially a large number in that day, the following day, none. So it's,
Right.
they
So
don't,
it's all
I
over the
really
place. So it
don't
might
see
be-
5 or 6 per day. It's
No, so it
sort
might
of
be
all or
10 or
nothing.
12, 2 days a week, or 3 days.
Right.
I'm not saying how it breaks out. I'm just saying the number seems so outrageous when you think about it, but if you break it down to the days, if you did them 5 days, if you did 6 of them or 7 of them in 5 days a week, that's not crazy, and you could believe that somebody might be able to effectively do that.
Maybe it's fair to say that this group has, recognizes that there are a number of high-volume providers.
No question.
And, the board should continue to look at options for, how to regulate without putting any, regulation or amount. That might be something to consider, because it seems like our numbers are kind of all over the place. We're not really sure.
Well, there was one recommendation about 1,000 per year.
Right.
Is there consensus on that?
I didn't
But
think
before
so.
we have consensus, I would like to know what the evidence being offered for that number is. I like your last bullet, monitoring compliance. I would like to see an educational process which allows standardized patients to be available to individuals who want to provide a number of IMEs over a threshold that we would have to look at and find out what the test is. And that individual would then see standardized patients, be compared to their peers, and then judged for accuracy, thoroughness, and decision-making. Otherwise, we're just pulling numbers out without evidence behind them. And I do not believe that that's fair to the claimant, and I do not believe that's fair to the physician. Because if you're taking somebody who's had 60 years of orthopedic surgery, taking a look at a knee, ankle, or shoulder, that individual is going to be able to reach a conclusion with perhaps with a high degree of accuracy when you compare that with somebody who's had 3 years trying to do the same thing. So we're not looking at physicians as in a like pool. And perhaps we should go back to that study that Stephanie gave us, and who are these 8 people that are doing 6,000? If it's only 8, perhaps we should have a closed-door session and talk to them. Find out what it is that they're being asked. Find out what it is, the specific questions that a carrier is asking them to come forth with. And we might be able to solve more by spending a few minutes with those outliers than trying to rein in a system where there may be only some outliers we have to look at.
I think the number of 1,000 is arbitrary. I'm the one who suggested it, and it is an arbitrary number. But I think what is a better way to address this entire issue is the second question is required to treat. Because we have doctors out there, we all know, whether on one side or the other, or just a treating physician, there are some doctors out there who just will give the same report for the same side, no matter what, without doing an adequate evaluation or giving a fair representation to the data. So I think what we should really say is doctors should be required to be treating, or possibly within 2 years of treating, maybe 2 years into retirement, in order to be allowed to do workers' comp IME exams.
Again, I'm going to ask the question, what is the evidence for that? If we're taking a look at somebody who is the chairman of shoulder reconstruction and joint disease, at one point he may feel that it's no longer fair to the patient because of the effects of aging that that individual chooses not to take a patient into the operating room to do a shoulder replacement, but still is in a wonderful position to perform a very high quality IME for many years after that.
Well, I disagree with that. I think there's a certain person who will end up being a hired gun, and we don't want those hired guns to be doing these IME exams. We want, the first word is independent, and these are supposed to be independent exams. And our big goal is to maintain the integrity of being independent medical examiners. And there are plenty of doctors out there, I'm sure you've been in practice long enough as I have to know there are plenty of doctors out there who are not independent in their exams.
That's why I have a concern with entities that are being approached by carriers to schedule patients. If that intermediary was eliminated, then physicians would be defined as independent in my eyes and yours, and that would go fine. But the requirement to treat and conflict of interest, I've been a dean for a number of years, the number of patients that a dean sees is different than somebody, as you're saying, who's on the front line treating patients. And that's important. But to look at the experience is valuable, but also I want to see evidence that gives us a reason to believe. If you want to believe that there's fraud, let's go for the evidence of fraud. And if you want to believe it, and if you want to believe it, then let's look for that.
Not true reports.
Okay.
That's great, let's go for that. Let's go after that. But to come up with an arbitrary number, though it might be useful, I'm afraid that it may also affect individuals and their ability to have a professional life without evidence for it. And I'd like to see
doctors. I agree, but I don't think that doctors should view IMEs as their retirement plan. And there are some doctors out there who that's their plan. And if they're going to maintain their independence, that's fine. But if they're not, and they're just going to be hired guns, that's a problem for the whole system.
Well, I agree with you, and that's the third bullet, the monitoring compliance. How do we do it?
So after listening to the two, both of the doctors going back and forth on the requirement to also treat, I hear one saying yes, one saying no. Just can you both clarify? I think Dr. Weinstein, you said there should not be a requirement, or there should be.
I'm saying, this is Goldberg, and I'm saying, no, there should not be a requirement.
And
Dr. Weinstein?
The requirement, I'm sorry, I missed the question.
Should there be a requirement to treat?
Absolutely.
Okay.
On the number of, this is Joe Canvas, on the number of IMEs or the limit and requirement to treat, I think that these things, from my perspective anyway, are things that we can do to limit bias. If you have someone who's tied to these IMEs as their only way to support themselves, and they perceive that the carrier or the employer wants something, I think that they are subject and susceptible to that perception, whether they realize it or not, whether they go in there and say they're going to tank this one, or it's something that just creeps in after report after report. I think that, I don't know that 1,000 is the right number, but I think that there should be a limit, and also possibly a limit based on a smaller time period, whether it's a day or a week or a month as well. As far as the requirement to treat goes, I think that also it goes to the financial dependence of the physician performing the exam, and quite honestly, and I know I'm going to get possibly struck here, doctors, at least in my experience, are extremely concerned with legal liability and malpractice liability. Doctors who are treating are going to be, at least in my experience, the ones who are the most familiar with current medical practices, with the most familiar with their field. Folks who don't treat, I think, at least have the possibility to let some of their continued training lapse, or their continued understanding of medicine. So I think that if you're looking at quality as well, you want a doctor who treats.
Hey, this is Brian. I have a few thoughts and comments. So I think our first concern we had was the number of IME providers we have in the system.
Correct.
So we're trying to cap their income. I don't think that solves that goal. We're trying to make them become treaters again. It doesn't solve the goal of enticing people to come into the system. And I also heard from Dr. Weinstein that he thought 6 per hour would be okay for IMEs. We just did a data analysis, and for the worst case IME provider, they do 6 per week. So do we really have an issue with IME providers, or do we need to market more to get more into the system? I'm confused on where we're at.
Well, I don't know that, I'm not disputing what you said, but I'm not willing to concede that 6 per week
It wasn't per
division.
week, it was 6 a day.
Six per day.
But that wasn't also the high end. Just looking at the data, there were at least 10 of them. They were doing anywhere between 5,000 to 9,000. That did between 5,000 to 9,000 within that 3-year period we looked at. 10 providers that did that. So it's a little higher than
Okay.
that, just to clarify.
So, Chair, I think it might even be a little bit higher than that, because I can't find the breakdown, but my memory is that when it was broken down by year, you could see that there were some of them who were like up and coming, so they weren't even in the top 10, but they were doing an enormous amount per year for that last year that the survey looked at.
Yeah, yeah.
And if you look at the number you just gave of 9,000, you divide it by 3, it's 3,000. Divide it by 50, because 2 weeks are going to be on vacation. Divide that by 7, that's 25.71 per day.
Well, and divide it by 5 unless we're going to work Saturday and Sunday.
Well, then it's going to go up, but if you did it working 7 days, it goes up to 25. I'll do it again.
And 6 per hour is half a day.
Okay, Brian, why don't you finish your thought?
Yeah, I think the numbers, and we're talking about 10 providers, and I think Dr. Goldberg said it before, maybe just have a separate conversation with those 10. We're spending an awful lot of time trying to solve the, small percentage versus the larger percentage of the system that is probably working okay. So I just think we're getting off on topics that maybe aren't solving our goal of finding more providers to do IMEs. That's all.
Which kind of leads nicely to, I think, the third bullet up there, which is monitoring compliance.
Before we move on, Brian, those Power 10 represented, although there are only 10 individuals, represented a very large percentage of the total IMEs performed in the system. I don't have the sheet in front of me, but it's significant. Chair, do you have that?
Yeah, so I'm looking at here, this is page 11 of our utilization study, section 3.16, if anyone else wants to cross-check what I'm looking at. So one of the bullets under here is that 2.5% of IME providers performed 72% of all of the IMEs.
Right, that's about 100, 110.
So that's about
not the
110
10.
IME providers in that 2.5% that did the 72%. So I think that's why this keeps coming back as a potential issue that we should look at, these high providers who, Dr. Weinstein says could be hired guns, could not. I mean, we don't know. I mean, is there something that we should be doing to get at that?
Right, so just one other piece of information we have related to that 2.5%, 40% of them both treat and perform IMEs, whereas if you look at all of the physicians doing IMEs, about 90% treat and perform IMEs. So the group that is high volume IME providers are less likely to treat.
Right, but that stands to reason. The people who are not treating have more time to do IMEs.
Right.
But it does seem to feed into the problem, which is the more wedded you are to one particular point of view, the more psychologically malleable you may be to bend your opinion to what you think you're being expected to say.
And the question is, if that creates bias, like, should we look at that, and how do we look at that?
And how do you look at that?
It seems to me that it's a little, I don't think it's a fair assumption that it creates bias. I mean, is one to assume.
Come on, be serious.
It's not an assumption.
Of course it creates bias.
That's not
Let's talk honestly.
Long experience.
Let's let her finish her point. Go ahead, Mindy, and then we'll hear
Thank
from others.
you. Then we'll attack you.
Yeah.
No, you should be allowed to say it.
Business council left you.
I have to say, I'm not saying there is no bias in the system, but I think that this focus on IMEs and bias is, I've seen my own IMEs are sometimes higher, give greater degrees of disability than the claimant's doctor. So I don't see how that represents a bias. The fact of the matter is, I think if you want to say we need more people in the system, I get that. If you want to say they shouldn't be doing too many, my thought is to not look at the macro level, look at the micro level, say how many could somebody reasonably do in a day if they did this the whole day. To my way of thinking, well, Dr. Weinstein said 6 an hour, So that would be, put a cap on how many you can do in a day. And that would sort of, but I think that Brian is right. Why should we disincentivize people from doing IMEs? Maybe it requires more training, maybe it requires, and we don't look at these things in terms of treating doctors, and I do think we should really consider that there should be a level playing field here. That's sort of an aside, but I think it's important to think about compliance, about fraud, about, all these issues should be considered across the board.
And I think it's more just about the 3,500 in a year. We don't want to discourage competent providers from participating in the system. We want to discourage less than competent or biased providers from doing the bulk of the IMEs, such
Let me ask a
as
question.
3,500 a year.
I hear that. I'm not saying that we don't want to encourage that, but by the same token, can the board tell us there are, 5 or 10 doctors I could tell you that see all my claimants practically? Can you tell me how many appointments and how many people they see in a year? It doesn't, I'm just, it's something to think about. You want to talk about people being treated properly and getting good treatment? Is that a concern?
I think Joey brought up an interesting point. I think it was Joey who said that maybe instead of looking at the absolute numbers, maybe the percentage of the income that the doctors make off of doing IME should be evaluated. I think that we can't have the hired guns, and we can say that they're not biased, but we all know that people are biased by who's giving them their paychecks. So much as doctors should try to be independent, and most do, there are ones who are not, and if they're getting their salary from doing one side of the equation, they're going to favor that side, and they're going to give the same reports a lot of times, and they're able to do high volume because they can generate the same report every time.
Well, I think Minnie said before that we have to look at the other side too, because I think there's bias on the treating provider side, if not more than there is on the IME side.
I think independence is the right thing, I agree. But
Again, that's
how do we
outside.
maintain the independence?
But that's outside of the purview of the scope of this committee. And it may well be a problem, but this committee was not formed to address bias on the treating provider side.
No, but the reason...
I agree, Justin. Thank you.
The reason we get IME reports is because because claimants' doctors' reports are not always
What you'd like to see?
No, reliable.
I thought that you got IMEs in order to deny claims.
What? He's kidding.
That's a joke, right? Right, Joe?
It wasn't.
I don't even understand.
I'm trying to help you here.
In order to controvert, I'm digging this all, and I'll step into it. I thought that the purpose for you getting IMEs was to limit benefits available to injured workers.
Why would I want to do that? I have every incentive to want to give them the benefits to which they're entitled under the law. I find that rather insulting that you would think I would want to do that.
So
And I don't think we should move on to.
Is there a?
I think, again, let's try focusing on the third bullet, which is monitoring compliance, which is, I think, despite, the going back and forth, I think, again, I can't speak for you as a group, but it's my sense, based on the conversation I heard, that we're looking to do something to monitor, to ensure that those people that are in this business that are doing this are somehow monitored. I don't know if the new system will help in any way, but for purposes of recommendations of this body, I think it's fair to say that this body, maybe not, is concerned about, the number of IMEs that are being provided, or however it is you want to word it. I don't think we can let this issue go away. I do think we can address it, not fix it, but recognize it as an issue for purposes of the report. The high volume numbers kind of speak for themselves.
So, and one of the things that I did hear, I'm sorry, that might be interesting to revisit. So there was a conversation about training, additional training for the IME providers. I don't know how folks feel about that, but that was, I think, maybe Brian or Dr. Weinstein did mention that. And there was also the mention of looking at their profits. I don't know how we could see that, but
Well, the more
That's what they
education,
did for.
oh, I'm sorry.
No, go ahead.
The more education, the better. I think
Yeah.
just as a single
So maybe some more
standalone point,
education.
that benefits every physician, including those that may want to get into doing IMEs. Maybe they have a smaller volume practice in upstate New York, and they're credible surgeons, and they'd like to try to do this, but the regulatory requirements for a small person are very difficult. Any form of education that a physician can avail themselves of, even mandatory, forgive me, is not a bad idea.
Which
Right.
actually kind of
I'm
leads,
look-
go ahead.
No, I'm looking at the word compliance. That means to be able to follow a certain set of rules. I have yet to see the rules. Perhaps you mean monitoring performance, not compliance, because performance would go to integrity, independence, and accuracy.
Right, I think
That's
that that's
fair.
exactly correct. And I think that maybe to focus on the numbers is not, and I don't know how to get to where the doctor is suggesting, but I don't think the numbers tell that story. I think
They
there
tell-
has to be some way to determine whether the IMEs are reliable, trustworthy, accurate, et cetera. Not, it doesn't matter if the doctor did 20 in a day or 2 in a day. Now, we all think that 20 seems out too many to do them accurately and, well, but the fact of the matter is that may not be the case. Maybe we have to make sure that we're going to measure the right thing.
So it's performance, not compliance.
I would-
think
Can
that-
can I ask a general question? If, right now, if there, and we all know, some doctors who just are the hired guns that we're worried about, what is a mechanism for them to be evaluated and determine if they should not be doing these exams at this time?
That's where I was actually going to go.
There is none at this time. That's why I raised the point about having standardized patients to be used to perform it. The other could be to take a patient that they have examined and have a consensus group of other examiners look at those same individuals. And Dr. Weinstein, you said something else which is pretty interesting. You said they produced the same report. Well, I'd like to see those reports. I'd like to see 20 from one doctor all saying the same things.
Yes.
And it would be unusual for that to be the case, and we could look at that. So the ways to address it would be, one, a re-exam by somebody else, and the second one would be, let's take a look at those reports that you have across your desk that you're making those observations for, because I know when I look at some treating doctors, I can say the very same thing, that the
If we step back-
paste machine goes wild.
Right, if we step back, maybe we should put in a recommendation to have a way to report the doctors who are considered to be not giving accurate reports. The ones who, I know one in Westchester, whenever he sees one of my patients that I'm treating, I know what he's going to say. He's going to deny treatment, shut them down, no matter what. And there's one in the Bronx who does the same thing. Those doctors should be sent before a board for evaluation and see if what I'm coming up with my patients is accurate and that this person is not doing independent medical exams, they're doing biased exams.
And this
I
is-
think that
So-
would not be a bad idea, but if we could do it with treating physicians as well.
But that's not
Again,
what this committee is.
That's beyond the scope of the committee. Dr. Weinstein, my only concern with your suggestion is that, I think it would put the doctors in a difficult spot. I know the professions who are self-policing generally are hesitant to turn in their own. So, I like the idea, but I'm just concerned that treating physicians wouldn't report their compatriots on the other side, maybe in fear of retribution of the IME doing the same to them.
But all
I agree, it makes sense. I'd be worried as an IME doctor as well that someone would report me, but I think we have to have a way, I don't have the right answer, but I think there has to be a way to report the ones who are really doing these egregious breaking of the rules.
And I'm sure first that the attorneys would be willing to help if the doctors feel uncomfortable with that particular type of thing. And this analogy is not meant to be superimposed here with any of the particulars, but so for instance, when a judge, I believe, turns 70 in the state, they either have to retire or there's a review process that they have to avail themselves of in order to stay as a judge for 2 more years, I believe, and forgive any inaccuracy in the particulars. But is there a review panel that could be put in place? And I don't know who would put it in place, but who could field those complaints and have some form of regulatory or other authority to then stop what they think is a failure of performance.
It's called the Office of Professional Medical Conduct that would review physicians to decide if that individual to maintain one's license or not. That process is in place.
Okay.
So, who would the obligation be to? Right, if you were to make a report to that office, what would they use, what standards would they use to evaluate the performance of a doctor who's an evaluating physician, not a treating physician?
I'm not a member of OPMC, I can't answer that question.
OPMC, which is,
Go ahead.
yeah, they're evaluating misconduct.
That's what I would
Allegations of
think.
misconduct. It's not about,
Whether they did too many reports in a
Right.
year.
It's not misconduct, it's Office of Professional Medical Conduct. And they will look at a number of things. They will look at substance abuse, alcohol, drugs. They will look at the effect that a neurologic degenerative change might have on an individual. They'll look at mental health issues. They look at many issues. Now, there is a committee on physicians' health that one can avail themselves of voluntarily, but if not, it goes to the OPMC.
And again, I'm not talking about old age or lack of health. I'm talking about more the performance issues that everyone is speaking of. Should there be someone saying, no, we looked at your reports, you did 3,500 in a year, they all look the same, and no more for you. And I don't know, I'm not saying that there's...
If there is a panel, if there is a panel or someone to determine that, it should be made up of doctors who do independent medical examinations. I don't know if doctors would report doctors, but there are some people who should be reported and evaluated, and I don't know the best way to set that up.
But lawyers do see situations that they feel are egregious, and I'm sure would have no compunction of saying to a panel made up of IME doctors, we think this person is really skirting the bounds of good conduct here. If the panel then, such as our self-regulating panels or the Commission on Judicial Conduct, had an obligation, notwithstanding that they were physicians, to make a recommendation, good, bad, or ugly, it's a regulatory mechanism. May not be the perfect one.
Or maybe through the medical society.
Again, the problem with I do not believe a membership society is the vehicle that should be used, because there are limitations in that too, because who is the medical society representing in that case? It's not a good question to ask of a society. And I do know that with respect to there is a population of orthopedic surgeons and neurosurgeons that have a tendency to take plaintiffs' cases for med-mal. And there is a committee within the American Academy of Orthopedics and within the American Academy of Neurosurgery that look at those individuals that do pop up or do show themselves around the country as being experts in what might be considered soft science. So perhaps we can ask those boards, what are they still in existence, and what their experiences were, and what challenges and successes did they have. Dr. Weinstein, are you familiar with the outcome of those bodies?
Yes, the AAOS I'm familiar with. They meet as needed, and they go through the cases, and they determine if the expert testimony was medically based or medically unbiased. And if they find that it's not, they will recommend that person be thrown off the American Academy of Orthopedic Surgeons, in which case they won't be able to testify anymore.
Forgive me, what is the entity within the board that determines, and I get the notices, whether an IME is permitted to continue beyond a particular date with what they're doing? Like, for instance, I've got notices that say,
The health provider?
this IME has been
Medical
removed
director's
from the
office,
list of IMEs that are entitled to do this because of X, Y, and Z. What's the board entity that makes that determination?
Well, the
Or
chair
board
has, the
itself?
chair has the authority.
Okay.
And the chair has, there are chairs designees that can,
Okay.
it depends on if it's a removal or it's a suspension. or a revocation, it depends on the exact situation, but you're talking about the subject numbers that you see, that
Yes, just
there are notifications of removal,
Yeah,
or
Dr.
revocation or
So-and-so,
suspension.
you know, has been allowed
Right.
to resume
Right.
doing this. Yeah, exactly.
Can we just circle back to Clarissa's idea, which was education? I actually think that was a very good idea. I know that in our office, we are required to take various, I don't even know what they're called. those
Mandatory webinars,
Mandatory
yeah.
webinars that we have to listen to and then answer questions about. And, on one hand, I think, oh, why do I have to do this? And again, but on the other, I think there's something to that. And I think maybe that, something along those lines would not be a bad idea, and something which really sort of emphasized the purpose of the IME is to be independent and to, give a thoughtful and accurate report. And I think that would, if once a year or every 6 months, that would to be required of every IME. I don't think that's a bad idea.
And to take that further, are the carriers willing to invite a physician to attend one of these programs, pay them for their time, pay them for their travel, pay them for their meals?
No, I'm not
As-
talking
then-
about
then-
program.
then- Yes, you
I think
are.
he's just talking about a
I'm not.
Saying like
webinar.
a webinar.
Then even if it's a webinar, that's 4 to 6 hours away from patients.
No,
You
I'm
fight
not.
tooth and nail when a physician shows up at a hearing which has been mandated for attendance, and it's very difficult to get that paid. So before you impose upon a physician additional burdens, please recognize that every burden comes with a cost, and that cost is being borne by someone. And please be very generous when you're requesting an additional burden that you fund it. Thank you.
I think Mindy's point was more that along the lines of monitoring performance, there be an education component. I don't think she necessarily said, again, correct me, that it had to be a physician.
No, what I think it should be is one of
someone-
those webinars. Does anybody else
Yeah,
have to
we
take
have to
these
do
all
them
the
at the
time?
state.
Well, I have to do
You know,
CLEs.
Yeah,
Well,
same
no, this is
time,
not a
right.
CLE.
Okay.
It comes on your desktop.
Right.
They say,
Yeah.
we are going to learn about, inclusion today, and what words you can use, what words you can't use. I'm not
Shooter
being
training.
facetious about
Yeah, no,
that.
it's true.
And it's usually
That's
about a
right.
half an hour, right on your desktop. You have to answer questions to get through the whole thing. And I think that something that said, here, that we want you to lend your knowledge, experience, and best judgment and all, considering all relevant facts to, to create this IME report. That's a good thing, right? Wouldn't that be a reminder, a constant, reminder that this is how you're supposed to approach these exams?
Does that clarify things a bit? But we could still be mindful that with every burden comes a cost. It's interesting that you put it that way, but it's true.
All right, at this point, it's almost 1:30. We need to kind of move off IME providers and now talk about IME entities, and regulation and monitoring therein, accreditation, annual reporting, and potential usage of penalties. To kick it off with regard to regulating IME entities, should the board require accreditation through an organization such as Utilization Review Accreditation Commission? And included in your handouts is some of the URAC accreditation material for existing IMEs. I don't know if everyone had a chance to look at that,
Mindy, it's just a,
but I think it's
The one
this.
page?
Yeah.
It's the one page, Mindy. Yeah, that's this one, right? Okay. Mindy, you can.
Yeah.
so most of the IME entities who participate in the system do not have URAC accreditation. Only 17% of the IME entities have URAC accreditation, and it accounts for 37% of the IMEs that are performed.
And when I see the word accreditation, I'm very sensitive to it as a medical administrator. That addresses a set of standards and values and missions and oversight and deemed authority by something to give an accreditation entity that privilege. does the Utilization Review Accreditation Commission have a deemed authority from any branch of the federal government? Do they have a deemed authority from any organized, recognized, deemed authority or subset? When one looks at medical schools, there's a Liaison Commission of Medical Education and the Commission of Osteopathic College Accreditation, which are deemed by the federal government to have that oversight ability, and they are held to task and they're audited on a very frequent basis by the federal government to make sure that they're independent from member organizations, that they are comprehensive, that they're balanced, that they have the ability to have appeals and due process. There are many, many, many standards that are oversight. So to say that there is a Utilization Review Accreditation Commission, I'm thrilled. I didn't see anything in the packet as to what that is and who calls them. Now, we do know that the for-profit medical schools in the Caribbean have gotten together to say, hey, we know that we can't meet the accreditation standards given that are imposed for U.S.-based medical students, so schools rather. So let's form our own. So the schools got together to form a coalition to have a consensus as to what those standards are. And no, they do not translate to the United States, but it is an accreditation agency. You can go online and look at any of the offshore schools, and you'll see how that works. So what is this entity and who gave them the authority?
I'm going to defer to you guys.
So URAC is known in the industry as being involved with, health insurance and I think other companies, and it's just sort of a best practices, if you have quality assurance and you do these certain things, that you're going to end up with a better product. So we selected URAC just as an example because we did see that some of the IME entities did take the extra step to get URAC accreditation, but it's not the norm.
So
Who pays for URAC?
The company that's, applying.
So the IME, it's like another self-policing type thing, right? So it's the IME companies pay to be accredited?
Generally.
So, I mean, if that's the case, it's like the fox guarding the hen house, right? If the organization is funded by the IME companies, and I mean, only 8 of them have done it, right? So only 17%, but it just leaves a question in my mind whether it's something that we should be really relying on.
I think, again, we're getting off topic. I would guess the low utilization for the URAC is because they have to have that for other states. Like in Massachusetts, you have to do utilization review, so you probably have to have that accreditation if they're in Massachusetts. New York does not require that, so I think the reason it's so low is because people need that for other states, just a guess. But if you look at what an IME entity can do nowadays, there's really nothing they can do except for administrative work, is finding doctors, mailing out reports, making copies. So I don't know what they need accreditation for, quality review for, because all they're doing is really doing administrative work for the carrier. That's just my thought.
Yes,
Go,
yes.
just sing out.
One more comment.
So from a carrier
Would you mind,
side-
I'm sorry, introducing yourself?
Oh, I'm sorry, I
I was
stepped
gonna
in
ask
late.
that
I
too.
was,
Okay.
Sorry.
I'm sitting in for Glenn Petrozello.
Okay.
From Amtrust, I'm Sue Howe.
Hi.
So
Okay.
nice to meet you all.
Thank you, welcome.
So from a carrier perspective, from an IME point of view, URAC is not necessarily something I'm looking for. It's the doctors that are performing the exams. When I look to have a company that is actually reviewing my MG2s, they have nurses involved in determining whether or not these treatment proposals are actually meeting the medical treatment guidelines. I look for a company with URAC accreditation. So from the IME perspective, I don't see that being necessarily a need.
Thank you.
When you say look to the doctors, meaning your experience, their reputation, your familiarity with them, or you said you look to the doctors when you choose something not to the URAC. When you say...
So when I'm doing the utilization review piece of it, it does not necessarily need to be a medical or a physician doing that, depending on their assessment of whether or not it falls within the treatment guidelines. But I want them accredited to provide that opinion for me.
Sorry, understood.
Yeah.
But when you're looking at an IME entity, you're more interested in the physicians.
Right, they're
That's
going to
what
be
you were saying.
qualified to do
Okay.
that
And I guess,
assessment.
Justin, what you're getting at is what about the physicians are you looking at? Was that what you were?
Kind of.
Yeah.
You know, do you look at, these are very, I don't know, they did work at the hospital for special surgery, or they did this, or they did that, or they're rated, you know, very highly amongst their peers. That was more of just, their
And-
credentials is what you're looking at.
And I don't necessarily have an answer to that. We do rely on IME entities.
Okay.
And going to the doctor's point about bias out there, it's absolutely out there. And I've seen those reports come through time and again saying the exact same thing. And we say, don't use them any longer. And I think Clarissa and Mindy, to your point, that educational piece, if we bring in the carrier perspective, I have no interest in getting an opinion that says the same thing each and every time. If I need to litigate something, I want to have a valid basis for it. No interest in increasing costs as a result of that.
I had a question for Stephanie in terms of this URAC. Is it possible, do they put out any best practices kind of information? I'm just curious, because maybe that's something, not that we want to make sure that everybody is accredited by them, but I'd be curious if they had any, you know, best practices that we might want to take a look at, that we might want to consider here.
So we can take a look and see what free material they have
Basically.
available on their website.
Yeah, I mean, yeah.
But the IME entities that came and spoke to us might want to, they might share it because they mentioned URAC.
Right,
Okay.
So we can put that in the parking lot.
okay.
All right, let's move to, so we're going to do a little bit more work on the accreditation, recognizing its limitations. Annual reporting of IME entity activity to the board. So the question has been posed to the board, mandate annual reporting of IME entity activity that would allow the board to delve into areas of cost, scheduling, subject matters, IME provider volume and quality, geographic breakdown, compliance with regulatory schemes, and other matters. So, you know, the premise, this body is charged with, you know, making recommendations on the IME process. We started, I guess a year ago, they started with a survey, which is a data capture in time. Should this be something that is looked at routinely, is really the question. What would be the value added to this group and to the board?
Looks like everyone needs a break.
Just thinking very deeply.
If we believe there might be a value to the Utilization Review Accreditation Commission or some such entity, then I think we would believe that there might be an interest and an importance to annual reporting, because that is what something like the URAC would be doing. And I like the items that you listed off, which we don't have in front of us, as the kinds of things. We would be able to see that if we have one carrier who's representing 70,000 injured workers asking for IMEs of 60,000 of them, and they're going to 5 docs, yeah, I think that would be kind of interesting, don't you? And some of that information could really come to light, and without having a URAC, by the way, URAC costs $27,000 a year once you're certified, at least according to the website that I just pulled up. And that was in 2003, according to Wikipedia. So it's not for free, but I like the question, are there standards? And let's see if we can catch it. I think that list you gave very quickly are some very valuable starting points, and perhaps if you circulate that to us, we could then consider them and perhaps add to them.
I agree.
Okay, so for,
So we can circulate that list.
circulate that list, which was again, cost, scheduling, subject areas, IME provider volume and quality, geographic breakdown, compliance with regulatory schemes, and other matters.
And requesting carrier.
Yep.
And state of licensure for the physician.
Don't all IMEs have to be licensed here in New York State?
Yes.
And board
If they're a
certified as well?
physician, board certified,
Yes.
yes, okay.
Not board.
No, we did that.
All right.
And there was something else we meant to put in the parking lot. I see we only have the one thing, but then at this point I have 3. What was the second thing we missed on here? Is anyone making?
Monitoring performance, including in education.
Oh, yeah, the training.
All right, and last but not least, so we'll get that list to you, potential usage of penalties. Question is, should the board consider the usage of IME entity penalties? Today, workers' comp law, section 13, allows for a penalty of $10,000 for altering an IME report. Altering an IME report could result in the imposition of this penalty, revocation of the registration, or prosecution by the AG. I guess the question is, do we want additional penalties? Do we want these enhanced? Do the penalties that we currently have work?
I think there are
Everyone's
penalties.
okay with the penalties as is?
There are penalties for other people communicating inappropriately with attending physicians that can actually amount to a criminal penalty, I believe, perhaps even a
Oddly,
misdemeanor.
it's okay. Steph?
And we do know, someone made reference to the fact that the names of individual physicians may be distributed widely if they are no longer deemed authorized by the board. And many of them say that their opinions after a given date may no longer be considered by an administrative law judge. So perhaps we want to look to that if a carrier is found to be utilizing an IME company that has been found to do the things that Dr. Weinstein talked about, said getting cut and paste reports, identical reports, high concentration of the providers, that the carrier's objections affected that given date that was discovered can no longer be used to go against an injured worker or to be used to prevent payment for a physician. That's a thought that I just had.
So we deregister IME entities. That's basically our administrative clout as to the entity. So really, I think the question on the penalties is, do we want to have any other monetary or other penalties that are directed at the IME entity? Because that would have to be added statutorily. Because, like we pointed out, the only statutory entity penalty is for alteration. But
that would apply to an IME entity as well, correct?
right, that's the only penalty that's
So
out
there's
there.
a $10,000 penalty, and there's also potential for deregistration, correct?
Right.
So those
And
are
that's
pretty
it.
hefty penalties.
But I mean, do you need
Do you
other
want more, right.
tools to, absent removing them completely, do you want other tools to kind of penalize them along the way to kind of correct behavior without the full removing them from the system?
Right.
In considering this question, I think it would be helpful to know how often the board recovers those penalties now, or deauthorizes, recovers monetary penalties.
Well, I don't think we have any, I mean, the only monetary penalty we can levy is the $10,000 for altering a report.
How often does that happen? So how often does it happen?
I don't honestly know.
I don't know.
You also have to keep in mind that, I'll put my free market hat on, is that the biggest penalty it gets is when we fire them for having 5 reports precluded in a week. So that's the ultimate penalty, I think, right there is a free market system.
And that's why this is linked with the question of, should there be an annual report as well? Because absent the information that a report would provide, the board only has information that's provided directly in an IME report. And it would have to be noted, we'd have to be aware of it in order to then pursue it. And sometimes, that general information and data about IME entity activity is not something that we have because we don't require it. So that's why those two things go hand in hand.
So is it possible for feedback on how frequently that is
We can
levied?
check.
Okay.
Yeah. I don't think we have a standard radio button for that one, so we might not be
No, I
able to find
understand.
out.
I
It's
understand.
going to be a search of language used in a decision.
Yeah.
Yeah, I mean, we'll
Yeah.
see what we can find out.
Okay.
And not to put you on the spot, Justin, have you ever raised it as an issue when you've seen it?
Well, I mean, it's a sample. Go ahead. It's a good question.
Then
Because my guess is it's extremely rare, if ever, that you've actually, seen it, but just in.
The answer is it's rare, but I don't know that it's rare that it happens, it's rare that I
Rare
see
that
it.
it's spotted, correct, right.
And then what I found to be the next most difficult problem here is that the physicians that are subject to what might be improper influence are themselves very reluctant to do anything beyond that. So for instance, a purely hypothetical situation. I may be sitting in my office in Kingston, and hypothetically, I may get a call from a local physician who I happen to have known for years that says, I have a completely random question for you that has nothing to do with any of your cases, nothing to do with anything we've ever spoken about. And I say, okay, what is it? And they say, is it proper for the IME entity to call me on the phone and tell me that they don't think I've properly interpreted the medical guidelines and that I should reinterpret them and write the report based upon what they think is the way to read the board's new medical impairment guidelines for schedule loss of use? And I say, I don't know anything about what the situation is, but of course not, absolutely not. And then I say, will you tell me who did it? And that's where it ends. And
But
so,
let me ask you a question. When they changed the guidelines and required doctor, and I'm not saying that anybody should encourage anybody to change the report, but I'm just giving an example where that kind of a conversation could happen, which would be benign, to say, the doctor didn't do the contralateral sides.
I don't
And they-
believe that conversation can ever be benign. I'm
No,
sorry.
Well, just listen to my example.
Okay.
Maybe I can think of one. So, they need to do contralateral sides, and he had not done the contralateral side. So wouldn't that be fair to say, you didn't do this part of the IME of the treatment guidelines or the impairment guidelines? Could you look at them again and consider what you were supposed to have considered the first time?
Utterly not. It would be proper for the IME entity or the carrier to send an IME 3 and a
No,
question.
you're right,
Please,
you're right.
if I may.
No, you're right.
To send a questionnaire to the IME, copied to all parties, which was the purpose of the entirety of that regulation, so that I could be copied on the request and perhaps the carrier's thinking behind it, and that way the doctor can make a formal response. And I have seen formal responses, and frankly, I've seen informal ones too, that I probably should not have seen because they were copied to the board file and shouldn't, where someone does or does not change their opinion in that regard, but there's a vehicle to do that, and it's not a phone call.
No,
And
you're right.
you do list one example that's okay, but where does that devolve into? I mean, where does the conversation stop? Nobody's monitoring it, and I can't do that with my doctor. I can't even text my doctor before the deposition to tell him what the issue is, because the board has deemed that this is the level of propriety with which we will behave and act relative to medical providers and litigation. What's good for the goose is good for the gander. If I can't call my doctor, you can't call yours.
I don't know, I'm not
Okay.
disagreeing with you.
I mean, that should never happen, never. And I wish that doctor would give me the name of the entity that did it. And I wish I had subpoena power, but I don't. But for instance, the question was not, oh, you didn't measure the contralateral side. It was, well, if you read this section, what it says is that you're supposed to consider the special consideration now, and if a special consideration applies, then you remain within the confines of the consideration. You do not just haphazardly add ranges of motion to it. We think you did this the wrong way. We'd like you to redo it a different way. No, the doctor should say, I read the guidelines the way I want. I'll be subject to cross-examination. Don't ever freaking call me again.
Okay.
Okay, we were talking about the potential usage of penalties. The board is going to see what, if any, information that they may have. At this point, I'm going to suggest we take a break. It's 1:45, and we'll come back at 5 minutes to 2 to hopefully move through the rest of this a little quicker, because we still do have a lot of stuff to do today. So, see you all back in 10 minutes. All right, I think we're going to start again. Are we muted? No.
Steph, are we muted?
You guys can hear us, yeah?
Okay.
We can't hear them. You want to mute them?
They have to unmute themselves.
Okay. All right, thank you. All right, we're going to get started again. Moving along, we are going to talk about same day, same manner. which is one of the few areas I think we seem to agree or could have consensus on, regard to the issues relating to the timing of notice of exam, filing, and service requirements. Is there consensus with the same day, same manner that it should be changed? If so, do you agree with the proposal to issue a hard copy to the injured worker, allow for an electronic upload to the WCB portal, and electronic notice to other parties? For notice to other providers, how far back should we go? And should we only include other parties of interest? So I'd like to open up discussion to first confirm our sense that this is one of the areas that there could be consensus on.
This is Joe Cannabis. I think that there could be, but I'm not comfortable committing right now.
Okay.
If there is consensus, I would like to see a hard copy given to the attorney as well. Hard copy to injured worker, hard copy to attorney, if so, the upload as thereafter desired.
Okay. Anyone else? Comments, discussions, sorry. Rochester, Wegmans, anything?
I think it looks fair to me.
How about you folks in White Plains?
We have no issues with that either.
Anyone else want to weigh in? All right. And Joe, we recognize your comment as well. All right, let's move along to IME provider assignment. Per the statute, the committee's final report should consider the feasibility of new methods of assigning independent medical examinations through rotating providers or panels, statewide networks, or other arrangements. And again, that's directly from the statute, and that is part of our charge. So I'd like to open up the discussion rather than going through all the individual slides to see what people's thoughts are in terms of other arrangements that we should be potentially looking at.
Methods of assigning, that means which doctor is chosen for which exam, essentially?
Yes.
Okay. Would it be correct to say that right now that is essentially done, absent the claimant requesting an exam, by the IME panel or group that the carrier retains to? Okay.
And if it helps to see what other states are doing, you have that as a handout. It's this handout that says selection of provider state by state comparison.
There's the 5, is that one? No,
Yeah,
that one.
5-page one. Mhm.
So Brian, I only had that handout.
Okay. You can try to email it.
Sure.
Yeah, that should be it.
I think maybe it would be helpful to read requesting party 29, that kind of thing out loud.
What was that?
Just trying to figure out.
It kind of summarizes.
Except for the states.
Okay.
So there were 29 of the states go by the requesting party. 9 utilize a panel or a board. 5 utilize a panel, board, or agreement of both parties. 5 utilize a panel or board list provided to be chosen from. 1 based on the agreement of both parties, and 1 is based on selection by employer and then approved by commission. And New York State falls within the requesting party group.
So I think the options that we have available to us really are the current process where either the carrier or the IME entity selects the provider they want to use. We could set up a situation where there could be panels used, there could be a network of doctors, and I think we've talked about, that the board used to have physicians on staff, but I can tell you from experience that it's very challenging to keep physicians on staff. So those are the options I think we wanted people to have an opportunity to discuss, raise questions about, so that we can at least respond to that request in the report.
I guess,
Hey,
please.
What?
Can I ask a clarifying question? On the requesting party, New York is a requesting party, but there's also a panel that we can choose from, because to be an IME entity in New York, you have to be part of the panel. In other states, you can just choose whatever doctor you would like to do for the independent medical exam. So I think New York is probably a combination of 1 and 2. It's a requesting party with a limitation on who you can select.
Let me just, I think, clarify that, if that's okay, and see if you agree with me.
Please.
When you say panel, though, in that context, you mean authorized by the board, as opposed to, we pick 5 authorized doctors and choose
Yeah.
1, right? That's what you're
Yes,
saying?
correct.
Okay. So it's a requesting party, but you have to be authorized by the board.
Okay.
As an overarching concept, I guess I would say we've spent so much time discussing how to get the most honest, competent, independent, fair doctors within the process. As long as that goal is accomplished, I think I personally am less wedded to any particular way that they're selected. And I know that that's a platitude, but if we can make everyone good, then select them however you want, wherever that may fit into this thinking.
I think that the selection please can help us make sure that everyone is good, right? I think that this can be another tool that we can use to eliminate bias in the system.
I would want to follow up with that. I agree with Joe, because if the selection of the physician is based upon a lottery or a rotating basis as opposed to a cherry-picked method, then that physician is not, the concern that I heard before about, someone said that if a doctor knows that they'll only be used if a report reads a certain way, if the selection is being done at random, that goes away. And then that physician doesn't have that additional burden behind them. The other one, which goes to one of the comments from Westchester, or White Plains, is that if a doc knows that he's going to be reviewed by somebody else on a random basis, that can act as a temporizing mechanism as well.
I don't see how you can say that you have to do this on a rotating basis. Are we saying that claimants have to go to treating doctors on a rotating basis? I mean, I don't understand.
Has nothing to do with it.
We're not discussing treatment, Mindy. We're talking about asking for an independent medical exam.
They're two totally different issues. One is who you choose to provide medical treatment. Another is a litigation tool used by a company or an insurance company or an employer. So they're two totally different things. To suggest that a treating physician should be chosen the same way is ridiculous.
That's not actually my
In addition to beyond the scope, yes.
If I may add just one point to that, to put a very fine point on it, wouldn't it be fair to say that the treating physician, while expected to be competent and honest, is not expected to be independent? These are independent medical examinations for...
But who generally sends the claimant to the doctor?
We have two big orthopedic groups in Albany. I say if you need an orthopedic group, you have one of two choices.
Okay, well, the fact of the matter is that's not always the way it's done. But be that as it may, I just want to point out that I know in the city of New York, we don't choose our IME we don't choose the IME vendor that we choose for each IME. And it's on a wheel and it's completely random. And we don't choose the doctor that the IME chooses the doctor. So between all of that, we're like 2 steps removed from who the IME doctor is. I mean, does it guarantee that there's, that everything is perfect? I'm not so sure, and I don't think it's all that different. I don't understand why the person why the employer has to go through a random wheel, that you have to tell them who they're going to use.
If we do random, the issue is going to be, and I have no problem with randomization, I think it's a good idea. The problem is, what is the fee schedule? Are we setting a fee schedule for what the doctors are paid?
But we're not even up to that yet. If we know that there are a small handful of doctors that are doing 9,000 IMEs, then certainly it's not a random wheel of assignment. Someone is singling them out to send that number, so
No, I think you're forgetting our much earlier conversation in that there aren't that many people in the system that want to do these. I mean, that was one of the things we discussed very, very early on. These 10 providers, to some extent, they're the default. They may not be the desired ones.
They're the defect, not the default.
Well, I think we're also figuring if you have a random wheel, it's all based on availability of the provider. And if you have somebody doing 9,000, they're obviously going to be the most available. So every time they come, their name comes up, they're going to be doing as many IMEs as they do today because of time constraints and who's available to do the IME. So I don't know how it works in other states. But in a panel, I'm only available to do one every other week. I'm only going to do one every other week. If I can do 9,000 in a week, I'm going to do 9,000 in a week.
Well, I think that you have to look at it holistically. The changes that are being considered are limits in addition to random assignment.
We want to assure that there are no IMEs.
So then there'll be no IMEs because I can only do 1,000 and there's no availability for the IME, so now I'm late because I didn't get it done in time. So I think that's a dangerous avenue we're going down with this one on the panel.
Well, if we go back to our previous discussions, I don't know how many months ago, we want to encourage more doctors to do IMEs. Something which we brought up at that time was either increasing the fees or making it an easier process or both. And we are not addressing that right now, but that's something which would encourage more people to do them.
Same day, same manner, I think, might help in the regulatory sense, because I have been told that that's a burden on some providers, especially the smaller ones, but only a thought.
If I could just throw out for discussion, one of the things that's out there, it's not very common, but is the upon agreement of the parties. And I'm just curious from the practitioners if there are circumstances under which, whatever the issue may be, the two sides come together and pick someone, and that would be the guiding opinion upon agreement. Does that happen?
I don't think I've ever done it. And I would only worry that the agreement would need to, I can't believe I would say this, come with some type of assurance that that neither party is just going to sit on it and not agree to it until it's too late to get the IME, legally speaking. I mean, and that's not even a purposeful thing. Carriers are busy. I call the carrier on Monday. They're out. I'm in court on Tuesday. They've got meetings all day on Wednesday, and we hook up on Friday. Well, that's 5 days that have gone by. So I don't know where that would fit into it. And I guess then I'll just be quiet and say I've never had occasion to do that, nor has anyone ever asked me to do it.
Then we probably could simply enter into a stipulation.
Probably, and there are plenty of doctors where I would say, sure, if you're going to do that, then I'm on board. There are some doctors where if you said that, I would say, I'll even give you a little extra time because of the doctor you're choosing. Now, that's very hypothetical, but it goes back to, I guess, Mindy's comment that if we could always choose the dean of the hospital for special surgery, albeit probably not available, that's desirable.
Is it fair to say that the group would prefer to leave it as is as opposed to discussing additional arrangements?
I'd have
or
to,
make modifications?
I'd have to
We-
actually think about it.
Okay.
We talked about annual reporting, and I believe if we were to get, if we were to drill that down, that might be able to guide the answer to this question. It may give us the information, because I cannot believe the distillation and concentration to so few physicians is random selection. I cannot believe it. And if somebody can, please enlighten me.
No, and it's not.
It probably isn't. I think we can all agree that it isn't.
No, it's not. I've worked
Yeah.
on both sides of the aisle, and I think done a fair job on both sides of the aisle, and there are certainly times when I would have preferred one doctor over another to examine whoever was on the other side, and I may even have expressed that.
I think some of the slides that we shared
Early on,
throughout
right?
the process also showed that the ones that do the most have the lowest fees. So to the extent that you're capping the amount that you'll pay for an IME, just by definition, you're going to have a lower pool or a smaller pool of physicians to select from. So that might play into it as well.
Would it be worthwhile to revisit this conversation and revisit those slides at the same time? I don't know. I'm throwing it out to the group. See if we
Touch
can
on the
build any kind
questionnaire.
of
Yes, it's going to be in the, we're going to discuss the questionnaire, and
Okay.
this topic is in there.
All right. So it's my understanding, and pointed out, that we are going to continue to talk about that topic in a few minutes. So let's move along to the appropriate use of claimant questionnaires. Actually, David, why don't we move to you to discuss the regulatory change?
Oh, well, that's just, that had been, I think, Stephanie distributed last
Yep.
month. And that's from that initial discussion on potential for parties agreeing on a waiver of the notice timing requirements, and perhaps under certain circumstances, the time to file requirements.
Okay.
And that draft language was out there, if anybody wanted to talk about it. So
Does
that's-
anybody have any
that's where we are.
questions for David on the regulatory change, the waive the timing requirements? No questions?
And Stephanie, the first bullet about the appropriate use of claimant
Yep.
questionnaires, do you want to take that one? or-
Sure. So at one point in the conversations over the last several months, the topic of claimant questionnaires was raised. I think Justin expressed a concern in the use of claimant questionnaires as part of the IME, because they're potentially signing their name to information in the questionnaire without legal representation there. I don't know, Justin, if you want to express your concerns over that, but in the packet, we've included two examples of claimant questionnaires that would come in frequently.
And I guess my thought, and I'm absolutely going to be confronted at some point with the question of, are you not putting forward a bit of circular reasoning? But that said, an IME can always verbally ask my client what they would like to know. My client, I would like to think, usually is doing their best to answer the questions, albeit lay people don't think or answer, forgive me, and accepting physicians, of course, with the precision that attorneys do. I look at this questionnaire and I see something different than my client does, and I read questions sometimes differently than they do. And I am not, for 1 second, excusing anyone that is disingenuous for any reason, and there seem to be, of course, appropriate penalties for that. But for instance, the first questionnaire that's on here, this is very lengthy. It asks a tremendous number of questions, very specific information. Frankly, all my client was told ahead of time was, if you really want this person to look at your x-rays or MRIs, bring them with you. This may be sent in advance, it may not. Half the questions on this first one are absolutely irrelevant. You know, your name, attorney's name, treating physicians in the last few months, those probably are necessary, albeit they can be provided by the carrier, certainly. And I know that the carriers do like these because they're an additional level of protection and/or / a litigation tool should they want to use it as such. I would be in favor of a much more constrained questionnaire or regulatory requirement as to what can be asked and what cannot. And again, I understand that these can be asked verbally, but you know, my client, as many times, will say, well, that's not exactly what the doctor asked me, or things of that nature. And again, yes, you can videotape the entire exam, and I know no carrier will agree with me. They're very much in favor of these, but I've never much, and I don't think many people on the claimant side view these as something fair, absent the ability to review it with my client ahead of time and to make sure that they're not saying something right, that or just don't remember, that I can not, you know, have them avoid a purposeful effort at fraud if that's what they're going to do. That's not on me. But to make sure that ministerial errors do not translate into 114A allegations unless there's some real substance behind them. So that was my thought. That's why I wanted to raise it. I don't think they should be used at all. I don't think anyone will agree. I think they could be more limited and still serve the same purpose. That's all I have to say.
I think that they're a trap that should be prohibited.
Okay, that's a bit more direct.
In sum and substance.
Are these examples of actual questionnaires that carriers use?
Yeah, somebody
I believe
shared
so.
this, right?
Well, yeah,
So, I mean, just looking at it, they trap injured workers into a multiple choice about what type of care they're receiving. They ask on there in English, right, written English, if they need a translator. Well, if they need a translator, they can't read the form. They provide very, very short lines to answer questions, and most importantly, in addition to the design of it being a trap, this is an interrogatory that injured workers are asked to fill out outside the presence of their counsel, and they should be banned.
Yeah.
So Joe, just as an FYI, these two specific samples that are in the package today were provided to us by IME entities several months ago when we asked about their process. We asked if they regularly use questionnaires, and if so, could they provide us a copy. So these are samples that IME entities are providing to the doctors at the time of the exam.
So I'm curious, what questions here are actually objectionable? Whether or not they had surgery, what body parts they injured, if they were sustained any fractures?
The design of these questionnaires show the bias. You're asking for an injured worker's medical history here, that the IME doc, I don't know, do they have access to it otherwise? Do they have any access to any documentation or medical records? Or does the person just go there and show up and the IME and doctor, you know, conducts the examination based on what the injured worker fills out on these questionnaires? I mean, I've gone through a handful that are objectionable. You're asking someone who maybe has multiple injuries how many surgeries they've had. What if the person's had 5 or 10 surgeries? What's going to happen is a savvy attorney is going to pick up on the fact that they've missed 1 or 2 and say fraud or try to impeach the credibility of the witness at the hearing. These are a trap and they should be prohibited.
Joe, when you go to the doctor, your doctor doesn't give you a questionnaire to fill out?
Well, actually, I was going to...
My doctor, I go to a doctor for the purposes of treatment, not for an opposing party's litigation strategy.
You know, Joe, I have to say, I don't understand. Have you ever gone to the board? Have you ever represented anybody in front of the board?
I am at the board regularly. I've told you previously, and you're not going to shame me or embarrass me. I have never represented an injured worker before the board.
That's right. So my point being, where do you think it's difficult if somebody needs to know how many surgeries somebody had? Why would that be an inappropriate question for an IME?
I'll answer that, and I have practiced before the board quite a
Yes.
bit. Because these questions are asked in medical terms. Okay, someone probably knows what diabetes is. Do they know what diabetes mellitus is? Does anyone truly, absent medical education, know what the definition of arthritis is? I mean, do that? Well, wait,
If
let me
they've
finish.
been-
Let me
have they been
finish before you.
diagnosed with it?
How about let me finish before you attack my opinion? Now, you asked everyone else for that courtesy. So, if I may, I didn't fill out a questionnaire this extensive when I applied for life insurance. This is way beyond, relevant past medical history, sure. Ask my client. And be specific. Listen, we're here for a shoulder injury. Have you ever had any past injuries to your right shoulder? And then add whatever else you want to add to it. But any question that's asked in somewhat medical, somewhat lay lingo has the potential to be nothing more, again, than a trap.
Don't you think you're demeaning your clients?
Absolutely not. Why does my client have to be asked, if my client is in for a shoulder injury for a loss of use, why do they have to be asked if they've ever been hospitalized in the past for any reason? Why?
Because they may have other conditions that are causing the disability they're currently experiencing.
But I don't think we get to go on fishing expeditions here on behalf of the carrier just to get a full medical history and leaf through the chart to see if we can point to anything to evade liability. I think the point is more to ask relevant, I know it's sigh-worthy, but I think the point is more to ask questions which the doctor can decide. A doctor is perfectly competent on deciding, should they choose to do an IME, what questions may be relevant to their particular examination.
If I'm not mistaken, these questionnaires are supposed to have been designed by the doctors.
Do you know that for a fact?
Am I correct, Dave?
Does anyone know that for a fact?
I think there are decisions from the board that actually require these to have been, they're not designed by the doctor.
I don't think that's, I've never.
I don't think that's true. Let me just talk this, the way I do, I do
Can you let the doctor?
I'm sorry.
Let the doctor talk.
Can the
Questionnaire is
rest,
not regulated.
You know, if one looks at, saying this was designed by a doctor, question 13, what treatments are you currently receiving? Physical therapy, yes or no? The doctor, that's not a doctor. Chiropractic, yes, no. This is skewed, it doesn't work that way. It would be your primary care physician, general practitioner, your physiatrist, your neurologist, your orthopedist, and then psychiatric care, it may have a place, but the others would come before that, and then later the allied health professionals. To start with them is not something that a physician would put together, in my opinion.
Okay, so let me ask
I'm
you
sorry,
a question,
Dr. Weinstein did
Well,
have a
I gotta tell you,
comment.
the way I would do this is I don't use a questionnaire that's this detailed. This is insane to drive someone, who's injured to fill all this out is insane.
Indeed.
I use a questionnaire that's half a page, 3/4 of a page, much more general, allowing much more appropriate opening questions that I can go into discussion when I get their history from them directly. So I do think a questionnaire is important, but it should not be such a yes, no, you have to fill it within this 3 lines. It's too limited and it's too big at the same time.
And again,
It's because it's a trap.
Right.
Stephanie, I have a question for Stephanie. You said you got these from IME entities?
Yes.
Did the IME entities, did they produce these, or did they give you examples from actual IME doctors that give that to you? Because our understanding is, through the IME entities we use, they do not use any kind of questionnaire. Any questionnaire would come right from the actual doctor themselves for their own knowledge. Employers, carriers do not ask for this typically in our view.
I do get many questionnaires attached to or sent with the IME-5. And that, again, at least I can look at it, but, well,
Can Stephanie answer the question?
She
I'm
says in
sorry,
the
can
question.
we permit Stephanie to answer the question?
So we asked, do you use a questionnaire? And these are examples of questionnaires that are used when the IME entity is the one that's actually distributing the questionnaire either to the doctor to be filled out as part of the exam, or it's the IME entities that actually have physical space and, doctors coming into it and they use it at that space. If the IME entity responded that, yes, questionnaires are used, but the doctors have their own, we do not have examples of those. So these are only ones where the IME entity had some role in distributing them to either the exam site or to the IME provider.
Thank you, Stephanie.
Out of the 15 companies I've worked with, IME companies, I've never had them give a questionnaire or show me a questionnaire ever. So I don't know which companies use these or how often they're used by other doctors, but I've never seen this before.
Hey, Justin, I have a question for Justin. Justin, have you ever seen these used as a litigation tool in all your experience?
Always. I'm not going to say hundreds of times, that's hyperbolic. This is probably, again, and I understand it's somewhat circuitous, but in addition to what my client says to the IME, the most common thing, other than perhaps the WA1 that's used as a tool in 114A litigation.
And I'll say just, from on the board panel level, we have seen them as well, used as a litigation. For what it's worth.
So Dr. Weinstein, would you be willing to share with the committee your half-page questionnaire?
Sure, I could bring it for the next meeting.
Please,
Okay, great.
please, that would be wonderful.
And question for the group, do we think these are necessary because we don't always get prior medical records timely? Is that part of the issue, that these questionnaires need to be developed for IME doctors so they can have some history before they do an exam? I'm just asking the question.
How about my answer would be it could be, but goodness, and I don't mean to be disrespectful to my clients, but they're not doctors. If you're getting the medical history for purposes of a physician's review and opinion from my client, I've seen as many IME reports that fairly start with, I'm doing my best here because the claimant is a somewhat poor historian or a terribly poor historian. This should not be for purposes of the physician's actual opinion. That should be the MRI report, if not the films, but at least the report, not what the claimant thinks that the MRI said, because with all due respect to my wonderful and beloved clients, they do not know what degenerative disc disease is, or spondylolisthesis, and so they're not going to fill this out properly.
Let's also keep in mind.
At a higher level of like they had back surgery 3 years ago. I wasn't thinking of the actual terminology.
Okay.
Well, let's also keep in mind that for the most part, people who get hurt at work are disproportionately people who do physical manual labor and not people who are attorneys, administrators, physicians. They are disproportionately folks who don't have to fill out legal forms as part of their job duties and may not have any experience at all filling out legal forms. So I don't think that there's anything, and they also are disproportionately non-native English speakers. So I don't think that there's anything offensive in keeping all of that in mind when determining whether this is a trap and a litigation tool or something that a doctor can use if the records didn't come in timely. And isn't there another avenue for recourse if the IME doc doesn't get the medical records in time?
They have 10 more days before that report has to be out.
Thank you.
And that's if the injured worker signs the release. If they don't sign the release, then you don't get the medical record. So that's the delay in the system that oftentimes IME doctors have to perform the IMEs without the prior medical records because the injured worker did not sign it timely. And there's limited recourse we have on our side to get the IME done timely without the prior medical record. So I think there's an imbalance there.
So they get 10 more days. What happens if the injured worker just refuses to sign the release? You can't have the documents.
I don't think the board would countenance that. I think they
Judge would direct.
Yeah,
So-
the judge would say, you will or withdraw your claim.
Yeah, so that's it. So the employer's not really prejudiced here by not being permitted to allow interrogatories in the doctor's office.
And I think, I can't speak for all employers, but I don't know of any employer that asked for this kind of questionnaire to be filled out. That's just my opinion, and if you didn't want to use them again, from my perspective, wouldn't bother me because we don't use them anyway. So, but I can't speak for all employers.
Well, that sounds like an area of consensus.
It does
Well, then,
sound like we have-
if nobody here uses them, then I think we should just all agree that they should be prohibited.
No, absolutely not. The questionnaires, these questionnaires should be prohibited, but not all questionnaires should be prohibited. It makes it easier for me to talk to the injured person of how they were hurt, the timing, the date, where they went to the hospital. It's easier to have them write that down. And I go through with them, and if they couldn't fill anything out, I'm doing it with them. But it should not be written in a way to say, do you have degenerative disc disease? Do you have degenerative arthritis? It should be written in very much layman's terms and in Spanish as needed.
Well, I've been presented with two really onerous forms here, so maybe I'll feel differently after I see yours, Doctor, but
Yeah.
this type of thing should certainly be prohibited. And if there's anything at all, they should be prohibited from being used as evidence in the hearings.
I think that'd be reasonable.
So maybe we can set some standards around what these should look like, that's what it sounds like,
At the least.
at the least. So we'll take a look at Dr. Weinstein's sample, we'll use that as a model, and then maybe we can fashion what they can actually look like.
All right, and, as you can see, it is on the parking lot, and we can revisit that next month.
Okay.
At this point, I think we are going to move to the review of the recommendations questionnaire. Today, what we are going to do is take a look at the draft, gather your feedback about the questionnaire and edit. After today's meeting, we are going to send out a finalized questionnaire to complete and return to the board by September 3rd. In the month of September meeting, we will review and discuss your responses and review an initial preliminary draft of the report. October, we will review a revised draft report, including your responses, and discuss as appropriate. In November, we'll finalize, and in December, the goal is to have submitted a final report. So-
Yeah, does everyone have that?
Yes.
Yes.
Okay. So do we want to walk folks through it? Does Stephanie or George, do you want to walk folks through the questionnaire, just what, all the different sections?
Yeah. So sort of piggyback on what Michelle indicated, we're looking now to try to coalesce around some recommendations where there may be some for the advisory committee with the goal of getting material ready for the report that we'll need to be preparing later this year. So what we did is we went through all of the issues that have been brought up over the last several months, and we also identified any recommendations that had surfaced up until, a week or two ago, and tried to put them together and in a way that we could get the committee members to indicate whether they agree with the recommendation, whether they disagree with the recommendation, whether they think status quo is fine, or whether they have some other recommendation that they would recommend to address the issue. So we have several different categories. The first one is volume, distribution, and availability of IME providers. So we have some statistics up there. We mentioned it earlier today about the small subset of IME providers who do 72% of all IMEs. So what we're looking for here, there's potential recommendations to address this. We could cap the number of IMEs any one provider can do in a single day. There could be annual minimums. For example, for orthopedics, require a minimum number of IMEs per year. Then there's status quo and any other recommendation. So essentially what we're looking for today is, do you agree with this format? Are there other recommendations that we should add now, or are there other topics that we should add now? Because what we will want to do is finalize this questionnaire in the next couple days, get it out to you so that it can be returned with all of your responses by September 3rd, so we can consolidate and have it available for discussion at our next meeting on September 10th.
So what's going to happen with the responses on September 10th? Are we all going to get everybody else's responses? Like, what have you decided to do with that?
Well, we can agree to that, but yes. Ideally, everyone would get everyone else's responses, and we would actually annex them to the report.
Can they be anonymous?
Can they be anonymous if the committee just deems so.
I
don't see a problem.
Who asked if they could be anonymous?
Nobody, not me.
Yeah, I think the expectation is that they're going to be shared, everybody's is going to be shared with all of the committee members, because the point of this is to try to see where we can drive consensus, or if not, report on the different opinions that are out there in that final report. And since that's a requirement, this seemed like the mechanism for assessing what's out there. So it would be distributed
And it
amongst the
doesn't have
committee
to
members.
necessarily be, in this exact format, but we do need to find a way of summarizing the points of discussion and any recommendations around any of the respective, discussions that we've had so far.
And I'm not
And then
trying-
if we can look at each other's responses, we might be able to identify spaces where there's actual common ground, or not, and we can, include that as well. I mean, we're gonna include
How are we
your
gonna
exact
decide
summaries.
consensus?
Is it possible, and not to,
Yeah.
like every other member of the committee want to beat me up, but if these could be, whatever format they're going to be in, circulated a few days before the next meeting, so we're not digesting them at the
Looking at
table,
them.
if we can all come in prepared with, and just get right to it, then
Right, as opposed to looking at it now.
So it was in your package, I did send them out on Monday, but maybe
Well,
like.
no,
I think it needs to complete it.
No, I
Oh, the
mean the
completed
completed,
one.
so
Okay.
that it's not that we're sitting down
Yeah.
at the table next time and it's, hey, here's everyone's response. If I can have it
Yes.
48 hours in advance, I
77
can be ready to talk.
So
Not that I'm not, anyway.
I think that's a great idea.
And can these be fillable also, like, online, so it's not?
Yes, we can send out an electronic copy to make
Right.
it easier for folks.
And I surmise if any of these required a little additional, you would not object to us appending page or a paragraph just to what we.
Yeah.
Of course, right.
So
Forgot
I
to
wasn't
ask.
being.
Oh, yeah.
I really wasn't being facetious about it, the anonymity. I think frankly that there are certain things that might be said that you might agree with, but you are, the person who's proposing it is somebody you generally don't agree with, and I think it might be better to say that they leave them, not that the board wouldn't know, but I think for the purposes of discussion, it might be more helpful to be able to look at them all and say, look, everybody agreed on this point, rather than say, oh, she agreed, I don't agree, or, I just think, or he said this, I won't say that.
But who at this table would do such a thing?
No, but I know.
But the point is,
I
that
have
everybody's
another
going to
concern.
fill.
What, David?
I have a random thought. We're going to be giving opinions on this. Some of us have other roles in our lives where we may be able to influence or attempt to influence lawmakers that may have an ultimate weigh-in on this. How, can we disclose conflict of interest as we submit our questions, to say that I work for XYZ organization and that will impact what I have, as a thought.
My other concern here is, we're back to the trap. These are your choices. I would be more in favor of, having the ability to edit this, not edit the document, but to include, maybe more commentary than what is, permissible here in this little box. So are we gonna be able to, to click on the boxes and type as much as we want?
Yeah, we can do
Yes.
that.
Absolutely.
All right, and the other thing is, I really do think we should own our answers, particularly if we're going to submit these all to you at the same time. So I'll use myself as an example. I wouldn't be able to change one of my answers based on the fact that maybe, for example, Mindy didn't, had the same position. I could comport myself a little bit better here sometimes, but I'm not quite that childish.
But as far as compiling the information for September 10th, do you want it to be a full compilation but have it, no position specifically noted, like Justin said this and Mindy said this?
Before you do that, did I hear that's too soon?
Yeah.
It is too soon.
Dr. Goldberg.
Well, so let's back up a minute. So the goal today was to kind of go through and make sure that we've captured Yeah, to the extent we have recognized, potential recommendations and we've left other, people have other opinions about what is the right answer based on the category. But the goal today is kind of walk through, make sure we've for the most part captured the discussions we've had to date, and give people an opportunity to agree with, a recommendation, disagree with the recommendation, give us a different recommendation. And I think, the hope was that we would get this back out to you quickly after today's conversation, so you would have a couple of weeks to pull it together. We would have the ability to get it back out to the panel members. And I think to Stephanie's point, we can certainly flip these back out quickly. If we set a deadline for 2 weeks out and you guys get them all back to us, we can turn those back to the committee within a day or two. But the question is for us to be able to summarize. I don't know if that's helpful for the committee or not, or if we just want to take them topic by topic when we get to the next meeting.
Wouldn't it be good, I think somebody suggested, I think Stephanie, you said, if there were, in other words, you could have an analysis. I don't mind having, I agree with Joe, I actually rethinking it, I don't mind putting my name, of course, to something, but if you could do the analysis without who said what, but rather 5 people thought this was a great idea, 3 people thought that was an okay idea, 2 people had 2 other ideas.
And I think this lends itself to doing that. So you think about, just take the first recommendation, day caps, the number of IMEs anyone can perform in a given day. We can bring all of these back and say, okay, well, 12 agreed, or 5 agreed, and 5 disagreed. So we can give you that initial snapshot, fairly quickly. It's going to be where we get to other comments, other recommendations, going to be a little bit more complicated to summarize and give back to you. But certainly, we can take this grid and fill in the summary of where they all came out, so you have a quick read. I just know that you guys would like as much time as possible with them before we all reconvene, so you have time to look at them. So I think our suggestion is, in order to give you as much time possible, we could flip you back all of the responses. We will also, in the meantime, be trying to summarize this in advance of the next meeting. So if you just think about the process, you have a couple weeks to fill it out. We'll give you back everybody's responses. We'll take the same 2 weeks before the meeting, roughly, to kind of summarize all of the responses back. So you'll have a summary document in advance of the meeting, but you'll also have.
But those would be anonymous?
Well, I guess that's the question for the committee. I don't know that it needs to be anonymous.
Maybe.
If
you have suggestions.
But that's what the committee prefers.
That's a decision for the committee. Do you want these answers to be flipped back just generically, remove all of the information about who filled it out and the summaries, or do you want the names in them? That's for this group to decide.
Personally, I think if an idea is a good idea, it's a good idea, and I would hope none of us would decide or not decide that something would be better or not for the system based upon any personality issue. I'll own whatever I write down there. And I'll own the comments if they're different than everyone else said. If you want to put Justin said this.
I don't think we summarize it back. We have to say who suggested it. We could just say, here are the other recommendations. I think this is just a discussion tool for us to see if, as we start to look at writing a report, do we have consensus? Are there other topics that are being raised at this point? Take those back to the group collectively and say, this comment was received, regarding how do we keep IME entities in this, or providers in the system, or how do we increase the number? Are people, in favor of this recommendation or not? So again, we really want to try to keep this as clean as possible. There are so many options on the table that I think it's going to be really hard to kind of get to a report. And I know it seems like we've got a long ways before that report's due, but it takes a long time to get this report finished and to get any kind of recommendations on the table. And we want to give you guys ample opportunity to review the report, make recommendations, help us edit that report, because it's your report at the end of the day. So we're just trying to find a concise way to gather the information that can be dropped in.
I think this looks good.
Form-wise, and I appreciate that there's the ability to always make a recommendation that's not in one of the boxes.
Okay. All right, any comments from White Plains, Rochester, or Manhattan on the form of this?
Just to be clear, is the agreement that we're going to fill it out and then circulate it, when it's due, and then the board will also summarize it?
Yes.
Okay. And, if I'm going to write it, I want to put my name on it. Is that what we're going to do here, or is it going to be anonymous?
It looks like others agree to put their names on it, right?
Yeah,
I have no
wouldn't-
problem putting my name on it,
Okay.
I just think it may be a little more fraught than other ones.
All right, and then my last question is, what happens if someone doesn't submit one?
Just be noted. I mean, we obviously can't force people to fill them out. I mean, we would hope
No,
they
you
all.
can't, but you can eject them from this panel if they won't stand behind their
I
positions.
think
I
we
think
probably,
inherently
just,
their
I think we'd
recommendations would be
indicate
there.
that somebody who was on the committee, officially on the committee, did not
Right.
participate in compiling potential
recommendations.
recommendations. I think that's what we would do,
Why would
probably,
anybody do
in the report.
But I don't think anyone would do that.
No.
that? None of these.
I don't think so either, but, parade of horribles and all.
Understood. Okay, moving on, let's, we are meeting again in September, September 12th, no 10th, at noon, at which point we are talking about, bear with me, I'll put my- the role of the fraud inspector general, potential crimes, having to do with altering the IME reports, falsifying applications for registration, and willfully disclosing claimant information. So again, I thank all of you who are listening and on the line. At this point, we are going to move into executive session.
Quick question,
Yeah.
before you move on, only because I believe they're here. Will the IG be saying anything to us, or just a discussion?
Staff.
The next
Next
meeting?
meeting.
Yes.
Okay,
They'll be presenting.
okay.
All right, at this point, I would like to move into executive session in order to discuss certain matters that are exempt from the open meetings law under Public Officers Law, Section 108, Subdivision 3, namely the results of the claimant survey. Please be advised that the committee will reconvene only to adjourn the meeting. So at this point, we are going to move into executive session. All right, we would like to again call the open meeting to order, and we will resume. The meeting is now adjourned. Our next meeting will be September 10th, 2019.
Thank you.
Thank you.
Thank you.
Thank you.